What I thought might be helpful would be if I just offered a brief recap of the paper's response to what I take to be the most serious challenge to formalism, or anyway, one of the more serious challenges, which is the objection from vagueness. So vagueness arises whenever you have a range of cases to which a term clearly does apply, a range of cases to which the term clearly does not apply, but then a range of borderline cases in the middle where the term neither clearly applies nor clearly does not apply. And this presents a problem for formalism because a lot of people think that there's just no fact of the matter as to whether a vague term applies to a borderline case. So if legally the outcome of a case turns on the application of a vague term in the law to a borderline case, then it seems like the law doesn't dictate an outcome either way. It doesn't direct the judge to an outcome. So to take the example in the paper, suppose there's an ordinance that bans yellow houses, and Bob the builder builds 100 houses. House number 1, clearly yellow, no doubt about it. House number 100, clearly not yellow. It's orange, maybe even it's shading into red, definitely not yellow. But houses 2 through 99 are evenly spaced on the color spectrum between house 1 and house 100. So house number 2 is just like a little bit farther towards orange on the color spectrum compared to house number 1. House number 3 is just a little bit farther on the color spectrum toward orange compared to house number 2, and so forth, all the way until you get to house number 100. And the government brings an enforcement action against Bob as to all 100 houses, and you're the judge. And so we don't get hung up on what's a question of law or what's a question of fact. Let's just assume it's a bench trial. You just have to decide which houses violate the ordinance. And a lot of people think, okay, house number 1, you should definitely rule in favor of the government. Bob's liable on that count. House number 100, Bob's clearly not liable. And maybe some other houses near the ends of the spectrum, legally there's a right answer on those. But houses toward the middle of the spectrum, there's just no fact of the matter as to whether they're yellow, and so the law doesn't direct the judge to an outcome on those counts. So the paper makes 2 responses. The first response says, no, actually there is a right answer in every case. So it's true, some people think that the uncertainty associated with vagueness is semantic, so it's a matter of indeterminacy in the meaning of the term. But other people think that the uncertainty associated with vagueness is epistemic. So the meaning of a vague term like yellow is actually, it's totally crisp. There's a right answer in every case as to whether a given object is yellow or not yellow. It's just that the answer is an extremely complicated function of the dispositions of all competent members of the relevant linguistic community. And we don't know exactly what form that function takes, and even if we did, we don't know exactly the values of the inputs into the function because we don't know with absolute precision what the dispositions of all of our fellow English speakers are about when to use terms, and so we don't know in the borderline cases. Nonetheless, there is a right answer. And the judge who has to make the call in the borderline case, it's not like a random guess. The judge has something to go on. She can go by her familiarity with her fellow language users' dispositions. And so the judge can make an educated guess as to what the right answer is. And in that sense, the law does lead the judge or direct the judge to an outcome. The judge doesn't have to make, in order to decide the case, doesn't have to look beyond the law. So that's the first response. Now, I offer some reasons in the paper for accepting the epistemic view of vagueness. I'm not going to try to summarize them now, but epistemicism about vagueness is controversial, so maybe you're not convinced. No problem. The formalist has a backup argument based on burdens of persuasion. So somebody always has the burden of persuasion in our legal system. Sometimes the burden is allocated explicitly, but even if it's not, there's this default rule in our legal system that says whoever's asking whichever party's asking the court to do something bears the burden of persuasion. And Tyler Lindley actually who's here, has a paper forthcoming in the Virginia Law Review where he explains the basis for this default rule. But anyway, it's a default rule in our legal system. So someone always has the burden of persuasion, which means even if there is this buffer zone of cases, in our example, some of the houses, it's neither true nor false that they're yellow, no problem. The law actually still provides the judge with directions about what to do on those counts. Presumably it's the government that bears the burden of persuasion because the government's coming in and asking the court to do something, namely sanction Bob for violating the ordinance. And so the judge should just rule against the government, not only on the counts where the house clearly is not yellow, but also on the counts on which the house is neither yellow nor not yellow. Okay, so that's the backup argument. Now, the realist, of course, can make trouble for the formalist here and can appeal to higher order vagueness. I addressed that in the paper, but I'm not going to try to summarize those arguments right now. Instead, I'll stop and just end by saying, there's a reason why the title of the paper ends with a question mark. This was actually Will Bode's idea. I owe the title to Will. He suggested making the title a question, and I think it was a good idea because I'm not sure that the law never runs out. I offer some arguments, some reasons why you might think the law never runs out, but I'm genuinely uncertain if I'm right. I very well may be wrong. So I'm looking forward to all of your thoughts. Like I said, I really don't know what the right answer is, but maybe you do, or maybe Jack does.
It is nice to be here. It's always lovely to come here, and I'm very pleased to comment on Charles's paper. Very interesting paper. I'm basically going to approach it from a very different perspective than I think Charles is writing it. So we'll have to do. But let me just give you my top points so that you'll understand where I'm coming from. So the first thing is that what's interesting about this paper is a very distinctive theory of formalism, which is not the usual theory of formalism. It's a different theory of formalism, and I'm going to talk about what's distinctive about it in a second. The second point I'm going to make is that this theory of formalism is actually incomplete. There are certain features of law and legal decision-making that it doesn't attempt to deal with, which is fine because it's a research agenda and there's future work. The third point I'm going to make is that although the foil in the paper is called realism, the version of realism is rather schematic. There actually is a historical tradition of jurisprudence called American legal realism, which I was raised in, really, and I know a lot about. And it's remarkable how the way in which this version of formalism is developed actually moves you closer toward American legal realism, even though American legal realism is the foil in the paper. And the fourth thing is I'm going to suggest that at one point Charles suggests that maybe that his view of formalism takes sides in the debate over whether there is a broad or narrow zone of construction in originalism, and I'm going to argue that it's orthogonal to this question, that if you understand what the debate about broad and narrow construction, zones of construction is, it has nothing to do with the issues that he's interested in this paper. So that a person like me who has a broad zone of construction and a person like Mike Rappaport who has a narrow zone of construction or none could both believe that the law doesn't run out, right? So, all right, so anyway, so I want to begin with what Charles means by formalism because he has a distinctive theory. If formalism means that in all or nearly all cases there's an outcome that the law, whatever the law is, directs the judge to reach. Okay, so outcome would mean a disposition of the merits or liability phase of the litigation. And this brings us to the first point I want to make about the piece. It's an incomplete theory of formalism. And Charles points out in the piece that his argument about formalism does not apply to the choice of remedies. So the law does not direct the judge to uniquely decide which remedy to choose, or the jury to decide which remedy to choose. So that's the first. Second of all, the account of formalism does not say much about disputes about the characterizations of facts, which are also outcome determinative for the disposition on the merits. The role of facts and disputes about facts and characterizations about facts, and the ways in which lawyers massage and characterize facts, and judges do, is actually very important for American legal realism. In fact, it's one of the major concerns of American legal realism. This is Jerome Frank's work, for example. And it's one of the most important reasons why legal decision makers might disagree with each other, even if they were to agree about the content of the law. People will see different things in factual situations and characterize facts differently, even if they have the same legal rules and norms. So, the third way in which the account is an incomplete account of formalism is that it focuses on the application of existing doctrines and legal norms to particular controversies before the courts. It does not consider judicial choices to change the law or develop the law through doctrinal development, through the development of novel legal theories and so on. These are a very important part of lawyering and decision-making. Much legal decision-making involves the creation and application of novel legal theories. These novel legal theories are usually not already inherent in the law. Otherwise, they already would be the law. So if we do not accept that the creation and implementation of novel legal theories are part of legal decision-making, we really can't explain how the law develops and how we say commonsensically that the law in 1940 is different than the law in 2025. Or otherwise, we have to take the rather unbelievable view that the law never really changes, or that all the legal legitimate change is completely foreordained by the content of existing legal materials. And it's possible you can argue for that position, but that's a much heavier lift than the position I think Charles wants to take in this particular paper. Fourth, the thesis about formalism is incomplete because it doesn't apply to choices about what kinds of new doctrines to create, whether we should create a rule, whether we should create a standard, whether we should create a clear statement rule, whether we should create a multi-part balancing test, and so on. It doesn't involve decisions about whether to change an area of the law gradually through incremental shifts or all at once, which was the subject of Larry and Randy's paper. It also does not take into account the question of how to craft and structure legal decisions so as to ensure that they're effectively enforced and respected by other branches of government, which is, in fact, is a very important part of legal decision-making, because if nobody's going to enforce your doctrine, or in fact they're going to find ways around it, then it's not going to work very well. So you have to spend a lot of time thinking about this question. So there's a great deal about the actual practice of law and legal decision-making that the article doesn't talk about. And these features are in some tension with the basic claim about formalism, at least in the way that Charles states it initially. However, since this is the first article in what I assume is a larger research agenda, these are all interesting topics for him to take up, and they're all ways that you could sort of resuscitate formalism in the context of all these features of legal decision-making. The second thing I want to talk about is the idea of directing, the law directing a judge. So that means, first, there's an outcome the law uniquely determines is correct. There's a puzzle here. If judges are allowed to change the law, then there's a question of how that meets up with the idea of the unique determination, but I want to skip that. Second, formalism also means that the law guides the judge's deliberation about the law to this outcome, so that a competent judge can follow the law. Once again, this is not about, doesn't say very much about factual characterization. It's important to understand that this account of formalism is significantly different from the versions of formalism that American legal realism emerged to contest. In fact, Charles specifically rejects these older versions. Charles points out that his claim is not that the law directs the judge to an outcome directly without referring the judge to any extra legal rules or considerations. Rather, his claim is that the law may direct the judge to consider extra legal rules and sources, like moral deliberation, or considerations of the public good to aid legal deliberation. As he says, the law might direct a judge to an outcome dictated by custom, other jurisdictions' laws, or even morality. And in fact, he points out that in addition to burdens of proof, there's also the duty of the judge to pursue the common good, right? This is the public trust idea. So once we take all these features of his account of formalism into view, there's much less difference between Charles's version of formalism and the historical approach called American legal realism. American legal realism argued for two basic propositions. The first was that the bare materials of law and abstract legal concepts were often inadequate to decide particular legal cases. Charles agrees with this proposition because he rejects the version of formalism that the realists rejected. The second claim is that the American legal realists made was that what leads judges, what directs them in Charles' terms to decide cases, is what Felix Frankfurter called the pictures in their heads. That is, their understanding of the social world around them, their characterization of the facts before them, and the requirements of justice and good public policy, or, in Charles' terms, the public trust requirement that legal decisions must be directed to the public good. These futures of human thought are inevitably involved in legal decision-making, the realists argued, and that is what makes legal decision-making determinative. It's what directs the judge to the decision. This, in fact, is Herman Oliphant's theory of law, a famous legal realist, and it's very similar to Brian Leiter's reconstitution of American legal realism in his work. The reason why law is predictable is, in fact, because law involves more than the internal reasoning from legal concepts, which is also Charles' view. Now, it's true that judges disagree about the social world, about the characterization of facts, and about the requirements of morality and the public good, but that does not mean they are not directed by law or they are acting outside of law. It merely means that a legal system with imperfect human decision makers countenances the fact that human beings with different views of the social world and of the common good may reach different conclusions about what the law requires. And indeed, Charles does not disagree with this position in his article. He emphasizes that judges have an obligation to make their best efforts at deciding what the law requires, even if they cannot be certain that their answers are correct. And once again, an American legal realist would not necessarily disagree. Well, okay. Then the question is, what is the difference between Charles's account of formalism and American legal realism? And the answer is different vibes. The vibes are a little different. But in terms of the practical way that law works, there's actually not that much difference. And it's because, in fact, he has expanded the notion of formalism to take into account different features of how human beings reason about what they ought to do in situations where they don't know the answer perfectly. And that is, in fact, legal realism. Well, and I don't mean, by the way, to insult you by saying that your version of formalism approaches legal realism. I mean as a compliment, because I'm a legal realist myself. The last thing I want to talk about is the interpretation-construction distinction. Charles mentions, he doesn't make a big deal out of it, but he mentions in passing that perhaps his account of formalism means that the construction zone must be narrow because constitutional interpretation is law-governed, and in most cases, the law directs the outcome of contested constitutional questions. But this, I think, is a misunderstanding of what the debate about the construction zone is about. It's orthogonal to Charles' concerns about law's ability to direct legal decision-making. So people like myself and Randy Barnett, who argue that the construction zone is broad, I mean, Randy argues it's broad, and I argue it's as broad as I am, we're not arguing that interpretation is not directed by law in Charles's sense of these words. Rather, we're arguing that one particular aspect of the law and one particular source of law, namely original meaning, is not adequate to decide a range of constitutional questions. But for a new originalist, like myself or like Randy, original meaning is not the only source of law that directs legal decision-making. There are many other sources of law that speak to constitutional questions, and they do direct judges' deliberation about constitutional issues in exactly the way that Charles argues for in his article. For me, examples would be structural reasoning, evidence of purpose, precedents, interbranch conventions, canons of construction, political tradition, and natural law. And we can also add the public trust doctrine that Charles mentioned. In Randy Barnett and Evan Bernick's work, the theory of construction does not assume that the law runs out. Rather, judges are instructed to consult purpose and function, which connects construction to original meaning. In short, somebody who thinks as I do, that you have a broad zone of construction, could agree with your revamped version of formalism. Whether I do or not is a complicated question, but I think it's not what the debate about construction's about. Thank you very much.
I'll be quick. Thank you, Jack. A lot to think about. I'm not going to try to respond to everything. One thing I want to say that I actually agree with is that, you know, when I started writing the paper, I thought that my position was going to be much more opposed to that of American legal realism, or at least the maybe Brian Leiter. If we take Brian Leiter as the representative of that tradition today, I thought I was going to be much more opposed to that view, and then I sort of gradually found myself making some concessions along the way, and then my view ends up a little bit closer to it than I started out. So I think there's some truth to that. Although I don't think that the view ends up being compatible with that of the American legal realists, because my understanding of their views is that the things that are the law, yes, so they put a lot of emphasis, depending on which author you're reading, but a lot of them put a lot of emphasis on how facts are characterized, or the sort of intuitive picture that a judge gets of the case that comes before him. And they suggest that the law itself doesn't direct the judge on what sort of picture to form of the case, or exactly how to characterize the facts. So in that sense, I think they do deny what I want to claim, which is that the law by itself, well, I'll have to qualify that, the law directs the judge to an outcome, even if not directly, still by means of pointing the judge to some other rule, which might be a rule of economics, if this is antitrust litigation, might be a rule of morality, if it's the First Amendment and Sharif is right. But there's going to be something the law points the judge to that is going to lead the judge to an outcome. I don't think that's the position of the American legal realists. On the interpretation construction distinction, so it's true. So I agree that you could endorse the thesis of the paper and nonetheless maintain that the construction zone is quite sizable, but just say that construction, no less than interpretation, is governed by law, by these other sources of law. So I don't deny that. And maybe I should have been a little clearer about this in the paper, but I was careful to say, if you accept this paper's arguments, not if you accept this paper's thesis, if you accept the paper's arguments, then it looks like the construction zone is quite small, because the arguments are meant to show that the communicative content of the Constitution, statutes, and so forth, the communicative content of written law does not run out ever, or maybe only in a very, very thin set of cases. And if that's the case, then I think you never get to the point where you're invoking these other sources of law in the construction zone, and the construction zone is small. So I agree that the thesis of the paper is compatible with the claim that there's a large construction zone, but I don't believe that the paper's arguments are compatible with that claim. And that's all I'll say for now.
Thank you. So I really like the paper, as you know, and if Jack's questions were about whether it lines up with the formalism-realism debate, I guess my questions are about whether it lines up with what you describe as the stakes at the beginning of the paper, besides that debate, like the confirmation hearings and Loper-Bright. At the confirmation hearings, the candidates, the nominees, have to say, no, I'm not imposing my value judgments, the law made me do it. And then academics jump on them for thinking that makes sense. But if they clarified and said, actually, when I say the law made me do it, I think what I really mean is that in a lot of cases, the public trust rule is part of the law, and it tells me to consult what promotes the common good. And in other cases, there's a multi-factor balancing test, but I can see and commensurate the rival goods and come to a morally best conclusion. And that's why there's always a right answer. That it would lose all the rhetorical force. The academics would get off their backs, but then the senators would be on their backs. And they wouldn't, this is not autobiographical, they'd have no chance at confirmation. And so I think it doesn't seem to match. And similarly with Loper-Bright, if the argument is, I take the debate between the Chief and Kagan there to be about whether the non-morally specified legal materials run out. And Kagan's point is, if they do, you're going to have to do policy reasoning, and it's better to have the agency do it. And Roberts' counterclaim has to be, well, actually, they don't. So does that fit with what you end up saying sometimes has to fill the gap?
I'm just going to echo Sharif's last comment, which was going to be mine more or less, which is, can you and Justice Kagan actually be in agreement? And or put another way, could the rule of Chevron or the rule of Auer just be a closure rule? Is that what she means by the law just runs out? Not that there's nothing for judges to do, it's just that that subset of law has run out, and the law then says, okay, the agency can make a rule now.
I came to this conference with one hammer, so I'm going to be hammering at all the nails that seem suitable for my one hammer, which is the theory of adjudication, theory of content distinction. So if you think of theory of content as establishing the normative status, the legal status of act types, there's certainly always going to be doubt with respect to whether a particular token event falls within one act type or another. That's part of what Jack's talking about when he talks about the different characterization of the facts. But if you think about legal content as concerning act types, I think that's what legal content is about. And then application is determining whether the particular controversy before you falls within one described act type or another. Okay. Burdens of persuasion have nothing to do with theories of content. They only have to do with theory of adjudication. So it can't be the case that burdens of persuasion plug every kind of gap that realists claim to find in the law. Maybe your other accounts would explain why it closes all the gaps in legal content, although that depends very heavily upon your theory of legal content. That is, the theory that legal content is reducible to or fully determined by communicative content. That's where the vagueness point gets in. But if legal content is some more complicated function of lots of different things, it could have threshold tests involved in it, where something is prohibited only if the factors that weigh in favor of prohibition push more, have more weight by some specified threshold than the ones going otherwise. That's just a gesture, but you get the idea that vagueness is not going to be the solution to all possible underdeterminacies with respect to content, depending upon the proper theory of content. And as I say, burdens of persuasion have nothing to say at all about theory of content. So I don't think once you recognize the difference between theories of content or questions of content and questions of adjudication, it could be that burdens of persuasion plug every kind of gap that realists identified. The last thing I'll just say is that sentence and a few others seems a little in tension with your emphasis on the genuineness of the Bodian question mark. So some passages like that read as though, you've got a question and you've got the answer, as opposed to being still somewhat unsure. That's a footnote, but the more important point is that burden of persuasions don't meet this need, I think.
Okay. Yeah, Sharif, I think there's something to what you said about the confirmation hearings. I think the part of the rhetoric is that we're separating law from or legal reasoning from moral reasoning. And one of the ways in which my view is actually not so far from that of legal realists is that I want to concede that sometimes applying the law does require engaging in normative reasoning. So I take that point. On the administrative law doctrines, though, and this addresses Elon's question as well, I think if you accept the arguments of the paper, then there are going to be only, so let's just, I'll just spot you the assumption that the dispute when it comes to Auer and Chevron is not about whether the law runs out in my sense, but rather about when the law runs out in the sense that in order to reach the outcome to which the law directs the judge has to engage in some kind of moral reasoning, do something like, the analysis under the public trust rule or something like that. Even if that's right, the arguments of the paper suggest that there's only a tiny, tiny little sliver of cases in which we're going to have to fall back on Auer or before Loper-Bright, Chevron as the closure rule. I think you put it exactly right, Elon. It's operating as a closure rule in those cases. So yes, and I think I say this at one point in the paper. If that's your view of the dispute between the Loper-Bright majority and the Loper-Bright dissent, then the arguments of the paper might leave some space for the Auer doctrine to operate, but it's a very, very small space, so I don't think it makes a great deal of difference. Mitchell, I totally agree that it's important to keep the distinction between theories of content and theories of adjudication clear. So I don't want to be fudging that distinction. I would say that the burdens of persuasion are part of the content of the law. And my claim is a claim, I actually don't make a claim about adjudication, how I think judges should decide cases, all things considered. I make a claim about the arguments of the paper entail a view on that question, only insofar as you assume that judges should, all things considered, what they should do is what legally they should do, reach that outcome that's dictated by the content of the law. Now, I actually happen to believe that's the case, but that's not a claim that I defend in the paper. Now, you are right that I make an assumption early on that something like the standard picture is the correct theory of legal content. Not exactly. So I think I agree with Will and Steve that the standard picture goes wrong in some ways, not quite as wrong as they think, but I think priority rules suggest that the standard picture isn't quite right. But I do operate on the assumption that something like the standard picture is true. Now, I know you reject that. So in a sense, you're going to get off the train at the first stop in this paper, and the reason why I just stated the assumption, didn't argue for it, is not because I don't think that pluralist positions like yours aren't worth engaging with or like, not worth arguing against. It's just I bit off more than I could chew in the paper, so it's going to have to be the next paper in the research agenda to defend that assumption that I state in this paper but don't really defend here.
Thanks. So this is essentially a follow-up to Mitch's question, because I had exactly the same concern, and Mitch put it better than I could. But I wasn't satisfied with your response to Mitch, so let me just try and put it in a slightly different way. So it seems like there's an equivocation here in this phrase, the law running out. So you're entirely right to say that there are default rules, and those, like burdens of persuasion, and those are legal rules. So we can all get on board that the law doesn't run out in that sense. But when people are claiming that the law runs out, they're talking about the substantive content of the law. Yeah, so they're saying it's because the law has run out that we are applying this default legal rule regarding burden of persuasion in order to reach a resolution in the case. The reason, one of the ways in which we can see that that's not going to the content is if we think about situations, and I think there's a lot of situations where different parties might bring the claim and might therefore have the burden of persuasion. So for example, in the UK is an implied term in every sale of goods contract that the goods are of satisfactory quality. So if I'm the buyer and I'm trying to reject the goods or get compensation, then it's my burden to show that they're not of satisfactory quality. But if it's action for the price, then it's the seller that has the burden of showing that they are of satisfactory quality. So I'm not seeing how the resolution of those cases can go to content when different resolutions will depend not just on which of the party is bringing the claim. Similarly, if the decision is appealed, so the appellant has the burden because they're the one asking the court to do something. So how can the content of the law turn on who won at first instance? So there's some reasons why I think it's wrong to suggest that this is about content and not just about adjudication. Thanks.
If your arguments are right, would they also apply to an agency following statutory instructions? Would they mean that even if a statute seemingly has a vague standard or has a multi-factor balancing test, there is actually just one answer, just one correct thing that an agency should do following those instructions? Or maybe if you have to deal with the equipoise problem, there would be just one thing they should do if you added a tiebreaker, like the status quo wins or whatever is closest to the status quo wins. And if that's true, if your arguments could be extended to agencies following statutes, does that mean, in fact, no statute ever violates the non-delegation doctrine? No statute is too vague because there is one right answer that an agency could find.
So I also want to take up Mitch's hammer, much like that of Thor, because it seems to me that the law can run out in different ways or for different subjects, meaning subjects of the law. So imagine that I'm the builder, and I have a contract to build these houses, but I also know that I have a duty not to build houses that are illegal to build, and that even my contractual duty runs out if it's an illegal contract. So I'm trying to decide how many of the 100 houses I can lawfully build. And it seems to me that in a certain relevant way, the law runs out. Now, it might well be that should a judge hear this case, and, as Martin pointed out, like the correct ruling for the judge might depend on the posture and the burdens. But it seems plausible to say that the substance of the law, in some sense, ran out, unless we have a view of, that this is purely epistemic, that there is a right answer about what is yellow, and sort of, we just all happen to be ignorant of that fact. But it seems like, for me, the law ran out there. And the fact that the judge will decide it differently doesn't help, because different rules run out for the judge at different times, such as when the judge is not sure whether I've got the slightly better of the argument or if it's an equipoise. So the fact that the point where the judge's law runs out is different from the point where my law runs out doesn't change the fact that each legal rule, whether it's the burden of proof rule that the judge has to deal with or the substantive legal rule about yellowness that I have to deal with, runs out in certain cases. And then it seems to me that the argument in response has to be that, in fact, it doesn't run out in cases of vagueness at all, that there is an answer about yellow. And there I wonder whether there might be other kinds of cases where that's harder. So take like the person who kills his grandfather to inherit under the will case, and imagine that the law has two provisions. One, devises of property by will shall be valid. Two, no man shall profit by his own wrong. And we're just trying to figure out, how do we combine those two things? Is this the specific controlling the general? And if so, in which direction? It doesn't, now one could say there is a right answer as to that. But it just seems hard for me to be sure that that's true. There could be better and worse things to do with this combination of legal rules that would better or worse serve the public trust. But it doesn't seem obvious to me that a jurisdiction has to have a public trust rule. So it doesn't seem obvious to me that there has to be a correct answer in this, given that the content of the law is determined perhaps by facts about each society, in which case facts about that society might mean it just stops.
Okay. So I'm going to pick up the Steve's and the first question sort of together, because I think part of the problem here might be a lack of clarity on, or an ambiguity in the phrase, does the law ever run out? Individual laws maybe run out. And that's the point at which the closure rules kick in. Now, if you accept all of my arguments, then you actually need to appeal to closure rules only very, very rarely, and maybe these special cases of equipoise. But suppose you're not on board, and so I have to fall back on my backup argument. Then I'm going to agree that sometimes an individual law, might run out, which explains why, if you're Bob the Builder, the law runs out for you. But nonetheless, the law, right, not any individual law, but the legal system as a whole, has not run out, because the burden of persuasion is part of the content of the law, right? And so if we limit the thesis, as I do in the paper, to a thesis about the law running out for the judge, right, the law as a whole directing the judge to an outcome or failing to do so, it may yet be the case that the content of the law as a whole is determinate enough to direct the judge to an outcome. But I take your point, both of you, that If you're not on board with my arguments about vagueness and balancing tests, my defenses of epistemicism about those issues, then you're going to say that the content of some laws runs out, which means that for some people, not judges, maybe the law as a whole runs out. And yet, I would suggest you should still agree with me that for the judge, the law as a whole does not run out.
Can I just ask?
Yeah.
So you're making a distinction between the law for judges and the law for other people in the system, right?
Oh, Mike. You turn on your mic.
Oh, yeah, but I think other people heard. So that's the distinction you're making? Yeah. So the distinction you're making is between the law for judges and the law for other people in the system, right?
Yeah, that's what I just said, but maybe I would, maybe I don't want to say it. Yeah, there is, I mean, there's just the law, period. What I want to concede, let me try to rephrase it. Okay. What I want to concede is that if you reject my defenses of epistemicism, which of course I think are correct, but I'll just set those aside. If you reject my defenses of epistemicism, then the law is not going to direct Bob to an answer to the question, which houses am I permitted to build? That's what I want to concede. And yet, I still think I can show that the law does direct the judge to whom the enforcement action is presented to an outcome as to every count in the complaint.
But at that point, the hammer returns, since the law for judges is a combination of legal content and rules of adjudication, whereas the law for Bob is the legal content without the rules of adjudication. At least that's what I understood Mitch to be saying. What do you think?
Sure, and so my thesis ultimately then is about looking at the content of the law as a whole, not only the primary rules of the system, but also the secondary rules, including the secondary rules of adjudication. What my article doesn't make any claim about is what judges should do, all things considered. But it certainly makes a claim about whether there's always an outcome that the judge should reach as a legal matter. And if you want to say that's a question of adjudication, that's fine, then that's the claim of the paper. I did want to say a couple of other things on like the Riggs v. Palmer type case. So Dworkin has a lot to say about this. Sometimes the law includes principles that have to be balanced against each other as opposed to rules. And I would say here, that's a balancing test. And so the judge has to engage in a kind of constrained moral theorizing. So what's the most plausible moral theory that respects the principles that are there in the law, and then use that moral theory to decide how to balance them. So here again, in a sense, take a position that's not so different from that of the American legal realists. I would just insist that the law is directing the judge to do that. And so it's not as if the law has nothing to say and the judge just goes off and does, whatever, but the judge is engaging in some kind of normative reasoning because that's what the law tells the judge to do. And then the question about agencies following statutes, yes, I think that most of the arguments in the paper, except maybe some of these arguments that appeal to rules of adjudication that may or may not apply to agency adjudications. I just don't know enough about that area. But most of the arguments in the paper, I think, do apply in that context. And so I think generally there is a right answer. And yes, I think even if a statute gives very broad discretion to an agency, that doesn't necessarily mean that we have a delegation of legislative power to the executive branch. And so maybe my interpretation of the non-delegation doctrine would be a little bit different from the prevailing interpretation.
It seems like colloquially, many people who call themselves formalists want to say, one, that the law never runs out, and two, that judges can decide all cases without, it's sort of in like an algorithmic way or in almost a deductive manner, or maybe without balancing in Sharif's sense or some sense like that. And so when you first sent this paper out, I kind of got excited because I have that same instinct, and I was like, oh, Charlie's going to explain why it is that I can believe both of those things. And you even call it formalism. And then it seems like you get the first part just by ditching the second part. In one of your questions on an earlier paper today, you mentioned the Wittgenstein idea that all rules end up being open-ended in one sense. So it seems like you do buy that, and you do make that concession. And so I just want to make sure I'm understanding you correctly, and if that's right, isn't it just a little unsatisfying? It feels like it's not scratching the formalist itch that I came here for.
I think my question is conceptually pretty similar to Micah's, minus the itch. I guess
Micah, I want to say that I do think of formalism as a kind of rash.
I guess I'm also interested in the clarification, and you started your presentation by saying, and I think in the paper you say, vagueness is the hardest issue for me. But I think you do a really good job with vagueness, at least when it comes to judging, and because of the closure rules that you mentioned that can usually direct an answer in any given case. I think balancing tests are the harder issue for you, because a truly open-ended balancing test that says without any direction as to how much weight to give to each of these things, just weigh these things and decide, I think it's what I'm getting at is, what does it mean when you say the law directs a judge to an outcome? Do we mean the law directs a judge in the sense that the judge can reach an outcome by looking only to the law? Or do we mean the law dictates a single outcome and only that outcome can be reached by a judge who is in fact following the law? If you mean the former, then I think you've made your case. I'm just not sure that your case is going to scratch anyone's itch. If you mean the latter, I don't know that you've made your case, because I just don't understand how, Judge Curmudgeon is going to follow the law, balance these things in a certain way, and Judge Softy is going to balance them in a different way. And each of them, even if they feel that part of their duty is to public trust or to reach the issue that best favors the common good, they have different conceptions of that. Each of them has reached an answer that was directed by the law, but each of them has reached a categorically, opposite answer. Are both of those answers directed by the law? In which case, the law didn't run out, but the law didn't accomplish what a formalist wanted to accomplish, or was one answer not in fact directed by the law? And how is it that the law tells us which of those answers is which?
Here, I have one point about the epistemic move with respect to vagueness of balancing tests. And that is, that's a controversial move in philosophy, and it is hugely counterintuitive. Philosophers adopt this move because it solves all kinds of problems, right? But I think I think that with your audience being sort of lawyers and legal theorists, the idea that, in fact, there is an exact number of pebbles that constitutes a heap, one pebble short and it's not a heap, one pebble and we just don't know what that number is. I think that that is not an intuitive picture from the point of view of legal theorists. And I think that you are applying the epistemic picture to open texture as well as sort of strict vagueness in the philosophical sense. And I don't see how you have made all the moves that are necessary to extend the theory to open texture, which is different in kind than vagueness. Just a second thing, these are just two things I'm suggesting you think about. Or let me just do one of them because I probably talked long enough already. I think it would be useful to you not to duck the question as to how your account interacts with pluralism. And let's just take constitutional pluralism, and let's do Bobbitt's version of constitutional pluralism. Because if Bobbitt is right, and when modalities conflict, all that there is decision, right? Then it does seem to me that your account is clearly wrong. And I don't understand how the arguments you make in this paper rule out Bobbitt. You certainly don't address it in the paper at all. And maybe it would be worth it for you just to think this question through and figure out how an explicit attempt to address Bobbittian constitutional pluralism would affect your argument.
Okay, I'm going to start actually there. And thank you, Larry, and thank you for slogging through this paper multiple times and giving me very helpful comments, which I hope you have seen the paper progress and improve as a result of those comments. I'm just going to agree with your last point. If you accept Bobbitt's theory now, is it a theory of constitutional adjudication or a theory of constitutional content? Maybe
it's actually a theory of constitutional content.
Okay. My thesis is wrong. I agree. And I don't say anything in the paper exactly as you claim. I don't offer an argument against anything like Bobbitt's theory. Now, I do state my assumptions there about the constituents of legal content, assumptions that exclude his theory. But just to announce that those are my assumptions is not to present an argument for them. So it's going to have to be another paper. But I take your point, and this is something you pointed out to me when we first talked about this paper, that a lot of people have this kind of view or some variation on this view, a pluralist view of constitutional content. So it's something that if I want to make my thesis appealing to a broad audience, I'm going to have to engage with at some point. And so stay tuned. Maybe that'll be the next paper or paper I'll get to shortly. About epistemicism being counterintuitive, yeah, you're absolutely right. I mean, vagueness is one of those issues in philosophy where there's like no position that doesn't have something deeply implausible about it, and it's just a contest, and like, you know, it's almost like a war of attrition between the two camps. Which view is more implausible is going to lose. So there's no question about it that epistemicism draws a sharp line where it seems like there is no sharp line. But you know, you think about it, and it's like if you're what's the alternative? Well, some kind of buffer zone theory. Well, suddenly now you're drawing two sharp lines between the clear cases on the one end, the borderline cases in the middle, and the clear cases on the other end. And those, the borderline between borderline cases and clear cases is no less vague than the first order borderline. And so the buffer zone theorist now has the problem twice over. And the only way to avoid it is to introduce a second order borderline on both sides. And then you have, you know, even more. So you have the Hydra problem. And it's really hard to see a way around this. I mean, you read the literature, and David Wiggins just denies the existence of higher order vagueness, but that doesn't seem plausible. So it's a really difficult issue. I find Timothy Williamson's defense of epistemicism persuasive, and so I'm inclined to accept it, but like I said, I might be wrong. And I agree, there's something counterintuitive about it. Okay, Tom, yeah, balancing tests are really hard. The arguments, I mean, I think the argument I make about balancing tests is very similar to the argument I make about vagueness. I call it epistemicism in both contexts, and I'm following the philosophical literature there. But I don't know, I might be wrong. I mean, I know Sharif argues that sometimes options are incomparable, which is incompatible with the epistemic view. Once the final version of Sharif's dissertation is out there, then I'm going to have to take a look at it, and maybe I'll be persuaded. So that I agree. That's a tough issue. On judges having different priors and therefore reaching different conclusions by applying a morally loaded legal standard. Yes, of course that's going to happen. So I distinguish between an objective sense in which the law directs the judge to an outcome and in the subjective, or I should say the objective sense of the outcome to which the law directs the judge and the subjective sense of the outcome to which the law directs the judge. So my thesis is that the judge can always, so my thesis is that there's always a right answer, right? And then the judge can always do her best to reach that right answer. The answer that the judge sincerely believes to be the answer dictated by the law is the outcome to which the law subjectively directs the judge, but it may not be the objectively right answer. And so just because, yes, of course, two judges might reach different conclusions in good faith doesn't mean there's no right answer between the two of them. And then Micah, yeah, I'm sorry to disappoint. I don't think that adjudication under the law in our legal system can be value-free all the time. So it can't be mechanical or algorithmic in that sense. The only thing I would say is to concede that rules are always open-ended doesn't mean that there's no right answer. I think there is a right answer. It's just that in many cases, it's going to involve some normative and moral reasoning. And we can debate about how often that's the case. But I think sometimes it's the case, and I agree with Sharif that in the First Amendment and Second Amendment context, there's going to have to be some normative reasoning if you're following the law to an outcome. And the last thing I wanted to say was actually in response to Steve, but he just stepped out, so maybe we'll get the next set of questions on the table.
Okay. Charlie, I just want to ask, why doesn't the paper title end with an exclamation point or something like that? Because your conception of law is so broad, it includes something like the public trust doctrine, that how could the law ever possibly run out in any circumstance? So Jack identified a bunch of situations that you haven't, you bracket off and you stipulate, I'm not applying to that. I'm not speaking to that, but surely there's an answer there too. And in fact, for Bob the Builder, why doesn't the golden rule also close the gaps to determine what he's supposed to be doing? So I guess on that sense, how could the law ever run out?
A skepticism running, I guess, in two directions. One starts from Micah's question about Wittgenstein and Quass, right? That is, it's highly counterintuitive to me that the person who goes to bat for the plausibility of Wittgenstein's point also will tell me that the law never runs out. And I understand that you square that circle by saying, well, the fact that the rule is always open-ended doesn't mean that the law runs out because there's more to the law than the rule. There are these various other kinds of moral reasoning. But for you to believe that that always will dictate a right answer commits you, I think, to some sort of perfectionist moral theory, which seems like a pretty heavy lift. And here's the second direction. In this specific context, the law, I believe someone once said, well, not exactly, is made for people of fundamentally differing views. Right? That part of why we have law, and the really neat trick that law does in a well-ordered society is it lets us get along and make decisions and run things and get the garbage picked up, even though we disagree about a lot of really important normative things, right? So it's not clear to me how a theory of law that requires a commitment to a perfectionist moral theory is going to supply a workable jurisprudence or workable picture of jurisprudence in a society where it is the job to enable the coexistence of people with a bunch of different normative views.
So my comment kind of builds on that, but from a historical standpoint. So the founders would have said three things. Natural law is part of our law. Natural law in some sense is fully determinate in a metaphysical sense. Some of them might have said that. Judges, I'm going to add a fourth thing. Judges have to enforce the law, and judges cannot enforce natural law as such. So those statements conflict with each other, assuming a consistent definition of law. But they would not have made that assumption. What they would have said instead is, there's a notion of natural law that in an abstract sense really is fully part of our law. And yet, in a legal system in which judges have a responsibility for putting people in prison and so on, there is epistemic clarity that is required. And so that's why we have positive law. That's essential to have like a known law. And so that makes me really, so you have just two different senses of the word law, right? Like one of which is fully determinate and one of which recognizes the epistemic underdeterminacy of the metaphysically fully determinate natural law, and therefore the recognition that there's a need for a different type of law that can be judicially enforced. And that makes me really nervous when you start talking not about metaphysical law in the abstract, fully determinate metaphysical law in the abstract sense, but start talking about applications. And so I share Sharif's concern about the Chevron point. And then I also really share Jack's concern about interpretation and construction. So you say in response to Jack, well, the freedom of speech is fully determinate. And there's a sense in which I agree with that. Like I think the founders would have thought as a concept grounded in a natural rights paradigm, subject to natural law limits and to the common good, both of which are like out there. So in some metaphysical sense, they are fully determinate. But in a practical sense, for a legal system, they actually are quite underdeterminate. And that's where you need to have construction. So like you interpret them, what do you find at the end of interpretation? Well, interpretation itself, because it's a legal mechanism in a positive law system, it has epistemic thresholds. And so at the end of interpretation, you have the law that runs out. And so I just worry that when you're talking about law in both of those senses, anytime your paper is engaged with some actual practical application of law, there's a slippage there.
Okay, first I want to go back to the thing I forgot to respond to Steve, now that he stepped back in. Steve, you said, well, what about jurisdictions that don't have the public trust rule as an uncodified rule? So my view is actually any system that didn't include something like the public trust rule, any system of social control would be not actually a legal system, but something more like a system of mob rule. So this is where I would, I agree with like 95% of what HLA Hart says, but I would qualify it by saying if the system does not include something like the public trust rule, it's not really a legal system. And that's why I'm more sympathetic to kind of a weak natural law view than a straight up Hartian positivist view. But now this connects with something I wanted to say in response to a few of these last comments, which is that the public trust rule, if I'm right, is relevant basically only when you have one of these permissive rules, like the rule, the plain error rule. I mean, it's been interpreted by the Supreme Court not actually to be permissive, so the Supreme Court has given necessary and sufficient conditions for reversing a plain error. But if you look at the text of the rule, it says the court may correct plain forfeited error affecting substantial rights. So you might think, okay, well, look, there's no outcome to which the law directs the judge in the event that the judge is confronted with a plain forfeited error affecting substantial rights, and the whole case turns on whether the judge opts to correct the error or not. And so in those cases, I say, well, no, if you believe that the public trust rule is part of the legal system, then still the legal system does, in fact, the law as a whole does direct the judge to an outcome. You might disagree with me, you might say that's not really part of our law, it's not part of the law in the relevant sense. At the end of the day, it doesn't make a great deal of difference, as I point out at the end of the section on permissive rules, because these rules they don't come up that often, and in particular, they're hardly ever, it's hardly ever the case that the outcome in one of these administrative law cases turns on the application of a permissive rule. You may be right. I have to think more about your question, Judge, so I don't have a great response to you, but I guess what I'd say is that if you accept, what I can say confidently is that if you accept the arguments in the paper, this problem is actually fairly small. Now, with one footnote, because something you said at the end is that if we have thresholds, like epistemic thresholds, then maybe there's more room for the construction zone grows in size, even if I'm right about some of the other things I say. And that's probably right. So I assume that as long as there is a right answer, even if it's really hard to know what it is, then we're still supposed to be doing interpretation and just getting to that right answer, doing our best. But if there's a second order rule that tells you no, when it's hard enough, when the interpretive exercise is hard enough, the answer is elusive enough, even if you can make a guess as to what it is, just stop right there and shift over to the construction zone. Nothing I say in the paper really excludes that possibility. So I take that point. Richard, so first, on the Wittgenstein point, so the fact that the rule is open-ended doesn't mean there's no right answer. So take the plus quas example. Once you get to 1,000, is there a right way to proceed? Interpretations of Wittgenstein differ on this point, and we're probably not going to resolve them today, but I think the answer is yes. You keep adding 2, and if you add 4, you're doing it wrong. So the fact that the rule is open-ended doesn't mean that there's not a right way to apply it and a wrong way to apply it. But that's controversial, though. I mean, you might disagree with me on that point. And then, yeah, I think there is a sense in which my arguments presuppose something like a perfectionist moral theory, but in a particular sense that I think blunts the force of your objection. So I do have to assume there's one course of action or one way of resolving a value trade-off that's better than the other. This is the epistemic position. But you could think that you could simultaneously hold that position and nonetheless agree that what the best thing to do may depend on how we as a society have agreed to resolve our disagreements about what the best thing to do otherwise would be. So we might think that actually what we ought to do, all things considered, sometimes is to set aside what otherwise we would take to be the best thing to do and go with the second best thing because that's what we've agreed to do as a society. And if that's your view, then there's no tension between the kind of moral perfectionism that my epistemicist view of value trade-offs implies on the one hand, and on the other hand, the idea, which I agree with, that a major function of the law is that it's supposed to resolve or settle our deep-seated moral disagreements.
Well, our questions. Perfect panel.